Matter of Deanna McIntyre versus Joseph Kazmark, file number 18-17496DS. Do we have anyone present on that?
I am.
Thank you. We have Ms. McIntyre present. For the court, what is the status of this file?
This case is an arrears only case as of March of this year. The defendant's balance is $27,625.12. Prior to March, the support obligation was $404. The last payment that was received was from a prior income withholding from April of 2022.
Thank you. Ms. McIntyre, anything that you wish to say?
He currently lives in my home. He is unemployed, and I've basically been supporting him out of obligation with our children. So I mean, I feel that he's capable of working. I just feel as though he isn't or hasn't. I've even offered to get him signed up for Social Security because he does have, medical problems in regards to his knees and all that. But I mean, it just falls on deaf ears.
Well, I mean, this money's primarily owed to you, and there's probably a few fees to the state, but not a lot. So what are your thoughts on what we do with the fact that there's this large balance out there? Typically, I do a bench warrant when someone doesn't show up for court to address it. Your situation seems a little unique, perhaps because he's living at your residence.
Correct.
So I guess I'd like your input on a bench warrant.
I mean, I don't even know if he'd, even arresting him would do any good. He just, I mean, I don't know. He just feels as though he's above the law, and he'd be released right away anyways. That's how his thinkology is.
Yeah, it sounds like you're potentially housing him. So is it your expectation to continue to pursue, and do you want to pursue this back support that is owed to you?
I don't even feel the only way we would get it is if he ever applied or was granted Social Security. I don't think he'll even get a job.
All right, well, given his failure to appear, I am going to do a bench warrant. He did not appear for this hearing to address any of the issues. He has a very large balance. So given his failure to appear, I will recommend a bench warrant in the amount of $7,000 plus $100 in costs. Any questions, ma'am?
Nope, that'll be it.
Thank you.
Thank you.
Matter of Thomas LaForest versus Rebecca Ledbetter, file number 19-17998DM. Do we have the parties on that matter present?
Thomas LaForest present, Your Honor.
Ledbetter, you need to unmute yourself.
Okay, can you hear me good?
I can hear you. All right, so we do have the parties present.
Yes.
Ms. Ledbetter, these are your motions regarding custody, support, and parenting time. Is that correct?
Yes, Your Honor.
All right, what are you looking to change?
Well, to keep it sweet and short, I'm looking for 50-50. I think that would be the best for our son. I guess,
okay.
I think it's only for 1 day a week, but I've been getting him for more days than notice that he opens up about the third day because he's on the spectrum, and he'll start talking. But then,
okay, ma'am, I don't need additional explanation. So I understand your position is you're looking to joint custody. Mr. LaForest, are you in agreement or disagreement?
Disagreement, Your Honor.
All right, is it your request that parenting time stay the same, or do you think there should be some adjustment to it?
I'm open to some type of adjustment to it, but not joint custody.
All right. So I asked because if there is some middle ground, the parties can try and attend mediation if they think there might be some type of agreement they can work on. If not, we obviously would just pursue forward with the court hearing. So Ms. Ledbetter, knowing that Mr. LaForest is willing to discuss some changes to the pairing time, but not necessarily 50-50, do you want to try and participate in mediation and see if you can come to an agreement before having a court hearing, or do you want to go
Well,
to a
Your
court
Honor,
hearing?
I wasn't doing anything besides what's best for Jacob. I think what's best for Jacob, for the last 4 years, I've been in everything but compliant. I've been doing
All right,
everything.
my question was simple.
I disagree.
Do you want to try mediation, or you want to go straight to the court hearing?
We can take it straight to court because I have done everything I needed to get my boy
All right,
back.
ma'am, again, don't need the extra information. All right, so we'll set the two of you for a evidentiary hearing. Ma'am, do you intend to call witnesses or just provide your own testimony?
Probably get 1 or 2 witnesses.
All right, and Mr. LaForest?
I'll be calling witnesses, Your Honor.
All right. So I'll give you a
And
longer block.
again, may I put on the statement, please, that this
No,
is
ma'am.
supposed to be what's
No,
best
ma'am.
for our
All right, I'll
son,
mute you.
not.
All right, so the parties are going to get a more extended hearing then, which I'm trying to set up, but it's difficult when I get interrupted repeatedly. I do have a date on May 4th. I know that is approaching pretty quickly. You both indicate you are going to call witnesses, so I don't know if that gives you enough time to get your witnesses together. Mr. LaForest, do you think May 4th is too quick, or do you think you'd be able to have your witnesses available and ready by that time?
I'd be available and ready by that time, Your Honor.
All right, Ms. Ledbetter, you can now unmute yourself only to discuss whether or not May 4th works for you, or if you need more time due to witnesses.
Yes, May 4th works, Your Honor.
All right, so you both committed to May 4th, so what we're not going to do is show up and then suddenly say we have issues with that time, because I'm willing to extend it out a few more weeks if you think you need more time, but the parties have indicated May 4th works, so we're going to schedule your hearing for May 4th at 9 a.m. That is a in-person hearing, so we'll see you here at 9 a.m. on May 4th. Typically, I do a witness and exhibit list, but given how fast that is approaching, I'm gonna have to make some changes to that. So I'll indicate if you intend to call witnesses or file exhibits, or present exhibits, you need to file a witness and exhibit list at least 7 days prior to the hearing date. Given that it's approaching quickly, I'll shorten that time frame. Any questions, Ms. Ledbetter?
No, Your Honor.
All right, Mr. LaForest, any questions, sir?
No, Your Honor.
All right, thank you. We'll see you back here in person then, May 4th at 9 a.m. You will get a copy of that notice. Thank you.
Thank you, Your Honor.
Thank you, sir.
Okay, for next, call the matter of Rebecca Degrees versus James Dash, file number 24-19634 DC. Do we have the parties on that matter present?
Yes, Your Honor. Elliot Blumberg on behalf of James Dash, who's appearing via Zoom.
Thank you, sir. And this is a status hearing regarding the final custody judgment. We do not have Mr. Grez present. Mr. Blumberg?
Judge, let me fill you in since last we were before you. We had a evidentiary hearing back in December, at which time you found Mr. Grez in contempt for denial of parenting time. You awarded makeup parenting time. You confirmed the parenting time schedule and also confirmed the party shared joint legal custody with primary physical custody to Mr. Grez. She filed a timely objection to that. We appeared before Judge Mertz. Mr. Grez again didn't show up for that proceeding. Judge Mertz dismissed her objection, and so your findings of December 17th is the order of the court. Since then, she continues to deny parenting time, which results in my client continuing to file objections to parenting time violations, and she's moved the child from one school to the other without the participation of the joint legal custodian. That's the status of this case now. We've attempted to have her held in contempt in front of Judge Mertz. Judge Mertz says, no, you got to go back to the referee and have her held in contempt. She's not here again today, Judge. You've already found her in contempt once. We would ask that her failure to appear today should result in a second finding of contempt. We are now going to be filing motions to change custody based on her failure to follow the court's order. I think the time for the court to hold this woman's feet to the fire and make her follow the court's order. That's where we're at.
Thank you. Are there any show causes set yet before me, or is that then coming down the road?
Your Honor, I can answer
Okay.
that. There is a parenting time complaint that is set for April 29th, but I believe there may be something to an ex parte to move that.
Okay.
In addition to that, there is a custody and parenting time complaint that is waiting right now. It was due to send a notice out yesterday, but because of today's hearing, I was waiting to do that.
Okay. All right. I do remember seeing that stip that I signed today. So Mr. Blumberg, that April 29th date was getting moved. Do you remember what date that was getting moved to?
I believe it was May 27th.
All right. So it sounds like we have another court date of May 27th to address those show causes. So what I'm going to do is adjourn this matter to that date as well. And then also Ms. DeGrez, as part of that date, needs to show cause as to why she did not appear today.
And Judge, by that time, we will have filed our motion to change custody. So maybe, at least for the initial proceeding, we can have that heard on the same day.
All right. All right. Sounds good. We'll see you back here then.
Thank you.
Thank you. All right, the court is going to call the matter of Cayenne Bauer versus Rex Drummond, file number 20-18350DP. Let's appear that the parties are present. Mr. Drummond, can you hear me okay?
Yes.
And Ms. Bauer, can you hear me okay? I'm sorry,
Yes.
is it Ms. All
It is Miss Bolden now.
right, thank you. All right, so we do have the parties present. And Ms. Bolden, this is your motion, is that correct?
Correct.
And what are you looking to do?
I am requesting modification for our legal custody agreement in the event that we cannot agree on medical making decisions, that I would have the final say or the court would have the final say.
All right. So typically when parties have joint legal custody, if they can't come to agreement, they can file a motion to have the matter heard in front of the court. So that does exist if you have joint legal. Are you asking that you have some other type of provision that says you make the decision if the two of you can't agree, or are you asking that we put some issue in front of the court that the two of you are not able to agree on at this time?
I would like it in front of the court.
All right, what's the typical issue what is the issue that you guys can't agree on at this time?
Our son was recently diagnosed with ADHD combined type. It's inhibiting his academics and also his home life. He was prescribed medication by his pediatrician. Dad does not agree to the medication, so he has not been able to take his prescriptions.
Okay, that certainly is an issue that the court does find itself unfortunately involved in at times where parents don't agree to some type of medication schedule. So that is certainly something the court can hear if the parties cannot reach an agreement. So Mr. Drummond, are you asking that we have a court hearing on that issue?
Yes.
Okay. Ms. Bolden, do you intend to have a doctor present to testify, or do you have records from the doctor about the visits and the recommendation?
I did obtain certified records from the doctor's office as well as signed affidavit from the school.
Okay. And Mr. Drummond, do you dispute that that's what the doctor is recommending at this time?
Yeah. There's not much evidence to give that kind of medicine to a 5-year-old, so.
All right, but you're not disputing that that is the doctor's recommendation, correct?
Correct. I'm not disputing that.
Okay. All right. I know you both have had attorneys in the past. Do you intend to have attorneys represent you at this hearing or handle this matter on your own?
I do not intend to have an attorney.
I don't either.
Okay. So I have I don't anticipate this being a hearing that lasts very long, given the narrow issue. I have a date on June 3rd at 11 a.m. Ms. Bolden, do you have any conflict with that date?
Let me check real quickly. That works fine.
Mr. Drummond, any conflict with that date?
I might not be in the state during that week of the first week of June.
All right. How about June 10th?
That'd be better.
All right. Ma'am, any issue with that date?
Would it also be 11 a.m.?
It would.
That is fine. I do have a question. Would seeking a temporary order in the meantime, since it is inhibiting him so much, be an appropriate action to take? Or June is pretty far out.
I do have to hear the testimony and the evidence. I have a bigger block of time available May 6th, but I could just give you guys a shorter period of time and keep some more time open. So I could do May 6th at 1 p.m.
I would prefer the May 6th date if that works for Rex.
Mr. Drummond, any issue with May 6th at 1 o'clock?
I'd like a little bit more time so I can talk with some doctors and have some more preparation for the court hearing.
All right. What about May 27th at 1 p.m.?
That would work.
Okay. So we'll kind of split the difference there. We'll set you guys for May 27th at 1 p.m. I mean, certainly a second opinion can be done and that information can be provided also. So we'll set you for that in-person hearing on May 27th at 1 p.m. I'll give you an hour and a half in case there's some additional information that needs to get in. That way I can also save an hour and a half for another hearing. So you guys will have from 1 until 2:30. Any questions, Ms. Bolden?
No.
Any questions, Mr. Drummond?
Nope.
All right, thank you both for appearing. You're all set.
Thank you.
North versus Michael Taylor, file number 17-16988DM. Do we have anyone present on that matter?
Yeah, I'm here, Your Honor.
All right, thank you. Mr. Taylor is present. Front of the court, what is the status of this file?
The defendant has a monthly obligation of $290 and a current balance of $2,029.06. Last payment was received in November in the amount of $2,000. Prior to that, it was October in the amount of $406.30.
I'm sorry, what was his balance?
His balance is $2,029.06.
Thank you. Mr. Taylor, anything that you would like to say?
I just started a new job. So whenever they send over their, what do you call that? The thing where they take money from me.
All right, how long have you had this?
About 2 weeks.
All right. The information given to me was that you haven't paid since November, is that correct?
Yep.
All right. Anything else you want to say, sir?
Not at this time. I'm coming in Monday to file a parenting time complaint since I still haven't had communication with my kids since our last court date.
Okay. I'm gonna turn your contempt hearing to a hearing before the judge, given the lengthy time since there hasn't been a payment. I will set it on his docket. He's got the date. I'll do a second May date, so May 22nd. And we'll set a purge amount that you can pay and have that hearing canceled.
Can't they just start taking it and take a little extra every week for rearages?
That's a potential down the road, but what I'm gonna do is make sure these things are happening, get you in front of the judge, given the fact that there's been no payment since November. If there's payments totaling $1,500 prior to that court date with the judge, May 22nd, then that hearing would be removed, and then they would just continue to monitor. From the court, do you have his employment information?
I would just like to make sure we have the correct information, if he wouldn't mind sharing that with us, or he can call and give that to me if he doesn't want to say it on record.
All right, Mr. Taylor?
I'm driving for Torpedo Transport Services out of Illinois.
Is that a W-2 employer or 1099?
It's a 1099, but I talked to the guy that hired me and he said you guys can send a, the thing where you guys,
Withholding
a
order.
garnishment or whatever it is.
So it's an income withholding order. Doesn't always
Yeah,
work with 1099s, but we'll see what we can do. But obviously, if you're getting payments and money's not coming out, it's on you to make those payments directly, as opposed to waiting until something gets set up. So if you're getting paychecks and it's not coming out, you need to make the payment yourself. Do you understand that?
yeah.
Okay. And if you pay $1,500 by May 22nd, that court date would be removed.
All right.
All right, thank you for appearing today. You're all set. Our next call on matter, Katie Kirk versus Jacob Moore, file number 18-17137DS. Do we have anyone present on that matter?
Here.
All right, thank you. We do have Mr. Moore present. In front of the court, what is the status of this file?
The defendant has a support obligation of $140 and a current balance of $2,546.43. Last payment was received in October in the amount of $110.38. We do have information that he may have started a new job back in the end of February. However, it does not look like the income withholding order is actively collecting, and I'm not sure if he is still at that same employer.
Thank you. Sir, what would you like to say?
I started working at Meyer probably about a month or so ago, or maybe a little bit longer. I know I did call and update that, and I thought that you guys, the front of the court, was getting the garnishment because I did get the paperwork in the mail, but I'm assuming there hasn't been any payments coming yet.
Well, do you look at your pay stub to see what you're making and what's coming out? And
I have not looked at my pay stubs. It's all on virtual, and I haven't figured out how to look it up.
all right, and what happened with the large gap of time without any payment?
I just wasn't working.
All right, and why is that?
I just was having trouble keeping work because I was in and out of the hospital for a little bit with some mental health issues, and I also had hernia surgery around the same time, so it was just hard for me to keep working at that moment.
All right, do you have any documentation to support those matters?
I really don't. I'm sure I could dig them up if I really needed to, but I don't have anything like offhand or anything like that.
Sure, you should be able to dig up a medical record if you had a surgery to support that. Were you in the hospital or was it just a day visit?
No, it was inpatient for like a week and a half, 2 weeks.
Right, and then did you have restrictions on your ability to do things after that?
No, sir.
Okay. How many paychecks do you think you've received so far?
Could you repeat that? It was kind of broken up.
How many paychecks have you gotten from Meyer so far?
I still didn't hear you. I do apologize. I don't know. Let me move. Can you repeat that one more time? I apologize.
How many paychecks have you received from Meyer so far?
Probably 4, 5.
Okay. All right, well, your case is very, very similar to the last individual who had made payments since November. I understand that you are working, but again, it's on you to make sure payments are coming in. Do you have funds right now that you can make a payment?
I am getting paid tomorrow. I know I am making $100 payment to front of the court with Montmorency. I don't know how much my check is going to be, but I will be making some sort of payment tomorrow when I get paid.
All right, I'm gonna set your case before the judge on May 22nd. If you make payments totaling $1,200 prior to that court date, you would not have to appear. Also, if you provide some type of medical evidence showing that you were unable to work for a portion of time, your caseworker may remove that hearing date if they're satisfied that supports that conclusion. If you're getting any paychecks before that date, you need to pay very close attention to what is coming out or not coming out. That is on you to
Okay.
make sure that that's happening. Any questions, sir?
No, no questions at all.
All right, thank you. You're all set for today.
Thank you.
Next call, the matter of Cassandra Guinea versus Greg Morgan, file number 24-19670DS. Do you have anyone present on that case?
I'm here. Is it working?
Thank you. Ms. Guinea is present. It looks like Mr. Morgan is present. Mr.
Yeah.
Morgan, can you hear me?
Yes, sir. Yes, Your Honor, I can.
All right, thank you. In front of the court, what is the status of this matter?
The defendant has a monthly obligation of $134 and a current balance of $1,141. The last payment made was in January in the amount of $250.
Thank you. Mr. Morgan, what would you like to say?
Yes, Your Honor. Back in January, I had projected to continue to be doing snow removal. There was a little splitting of crews at work, and I was unable to keep doing that. And in the months of February and March, we had a lot of snow. Work was not very consistent. Recently, I just started a project that I should be wrapping up on Friday, so I will be able to make at least another $250 payment, depending on what time I get my check and what time front of the court closes on Friday. But I don't, like with the weather breaking and everything like that and everything else, I don't foresee me having any kind of trouble making consistent payments and making double payments per month until I'm caught up.
Ms. Guinea, any questions or anything that you would like to say?
Just that I wish she would pay for child support. I mean, I don't know what to say. Like, I mean, our kids are doing after school activities and, you know, just some help would be really nice if he would just, I mean, he's helping his adult children with money and it's like pulling a needle out of a haystack trying to get help from him. And I just, it is what it is. I mean, I asked if he could help with baseball for our 6-year-old and I get a response that I'll put 50 towards his cleats. Like there's more than cleats that go to baseball. It's just exhausting. I work third shift. I mean, I bust my back, my boys, and just some help would be nice.
Okay, thank you.
And then there's also I also was, you know, I just added my kids to my health insurance back in January. So like that's an extra $200 get taken my check a week because our state insurance is not very good. Because I had our son had surgery last June and I had to pay $100 copay just to get him to have surgery. I'm like, I'm just gonna add him to my insurance through work, which is Blue Cross Blue Shield, which is way better up here in Northern Michigan. And it's just, it's just little things. It's just,
Are you making payments then for that health insurance coverage?
Yeah, I get $200 taken out of my check a week for my family, but I mean, it's not all of the 2 boys. I have only 6 on there, so it's like a portion of that is the 2 boys.
Sure.
Yes, they have health insurance. They have mental or dental, vision, and health through Blue Cross Blue Shield through me now through my work. Full.
All right. Well, potentially, if you're making payments, there might be some additional credit you could get if it's not factored in currently for providing the health care.
Your Honor, I have a meeting scheduled with her to discuss all of that.
Okay, perfect. All right. So yeah, man, make sure you talk to your caseworker about that. If you are making payments towards healthcare that was not previously considered, then a new support recommendation can be done to address that amount. Okay.
Okay.
And in front of the court, the 134, does that include arrears? If you know.
No, this obligation just started charging back in July.
Okay.
Due to the defendant's incarceration.
So, Mr. Morgan, what do you think is a feasible amount for you to pay per month?
I'd like to pay a double amount a month until it's caught up. And in response to what Miss Guinea or Mrs. Guinea said with the whole baseball thing, I did not just say $50 for cleats. I said, well, she paid $50 for the sign up. I said, well, I'll cover the cleats, bat, glove, everything else, which will exceed your $50. And I will show that I want to put in an effort. I don't know where the breakdown and miscommunication came in from there,
Right.
but I do apologize for that.
Right.
But
I'm not here
I can
to get those
definitely
kind of
make
issues.
double
I'm
payments.
going to address, sir, what you need to get in. So you missed February and March, correct?
Yes, Your Honor. I can, like I said, I can make double payments per month until I'm caught up.
So you're saying you feel you can pay
$250 a month until I'm
$260?
caught up. Well, I was going to say $250, but $260, yeah, that's fine.
All right. I'm going to set you for June 3rd. I was considering setting you before the judge, but I'm going to give you one more shot to get some payments in here. I'm going to set you for June 3rd. With the expectation that you're paying at least $260 for April and May. It's really not double payments because you missed February and March. But
I
if you pay
understand.
those, and continue to pay the $260 throughout the rest of the year, then you will start getting yourself the extra payment. So if you pay $520 prior to that June 3rd date, you don't have to be here. And then what we would do is reschedule that for August 5th. So another 2 months down the road. And we're going to keep saying the same thing. If you get the 520, so 260 every month, we'll keep adjourning the hearing until we get you back on track. Do you understand?
Yes, Your Honor.
If you don't pay that amount, you'll come in front of me. And if you haven't met that amount and there's no valid reason, then I'll send the matter to the judge for further review. Any questions, sir?
No, Your Honor.
Ms. Skinny, any questions?
No.
All right. Thank you both for appearing. You're all set.
Thank you.
The record would call the matter of Tasha Butts versus Ronald McCluskey, file number 11-14145 DP. Do we have the parties on that matter present?
Yes. Ronald McCluskey.
Right. Mr. McCluskey is present. Ms. Butts, or if you're present, please unmute. And can you hear me okay, ma'am? I see somebody labeled as Tasha is present. If that is Tasha Butts, you need to let me know that you're here. Might have some trouble being at our audio.
Your Honor, I did send her a message on chat for her to check that, so it appears it's on now.
Okay, thank you. All right, Ms. Butts, you are muted, so if you could please unmute. Ms. Butts, can you hear me okay? All right, I cannot hear you. Ms. Butts, can we hear you now, please? All right, I'm not hearing her. Mr. McCluskey, are you hearing her when she speaks?
No, sir.
All right,
It's muted.
now we got
Can you hear
you.
me? Okay.
I can now. All right, thank you. All right, so we're here on the Butts. This is a motion filed by Ms. Butts. Ma'am, what are you looking to change?
Actually the visitation, it's not, I would like my daughter, I'm having a hard time getting her to go. She's not wanting to go. She's feeling uncomfortable. So I filed a motion.
Okay. You're asking that the visit stop?
Yeah, she doesn't really want to see her dad anymore. I didn't realize that it had been damaged as much as it had. You know, I'm not in the middle of the relationship. I don't, you know, so
Ma'am,
I had to.
Ma'am, I don't need to get in all the reasons right now. It's just what are we looking to
Okay.
do? And then we set a court date if we have no
Okay.
resolution, but essentially you're just asking that they stop. Sir, are you in agreement with that or disagreement?
I disagree.
Okay. Then what we would do is set the matter for a hearing. The child would have a right to do a preference interview with me and or appear as a witness if you wanted Ms. Butts, but there certainly would be the preference interview as well. Ms. Butts, do you intend to call other witnesses or essentially the big thing is for me to speak with her?
Yeah, no, it's all her. So
I think a 1 hour time frame would probably work then for the evidentiary hearing. The evidentiary hearing would be May 6th at 11, unless either one of you has a conflict with that date. Is that date available for you, Ms. Butts?
yeah, that'll work.
And sir, are you available that date?
Yes.
And I think there were some also show cause and some parenting time issues. Is that correct?
Yes.
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 All right.
We have court on the 29th.
We would address all those matters on the May 6th date. So the other court dates that you have, it looks like Ms. Butts has a show cause on April 29th. We would just address that on the May 6th date, which would be the time set aside to deal with those. No need for you guys to show up on the 29th, just to be told to show up on the 6th. And we'll address any and all potential parenting time complaints that exist at that time. So if there is ongoing violations, we can address all of that on that May 6th date.
Okay.
Any questions, Ms. Butts?
No.
The child should be here about 10:45 for a preference interview. And again, the preference interview is a confidential interview. If Ms. Butts, if you want her, she can also provide testimony. That's your call as the party to the case, but I certainly will do that preference interview. Mr. McCluskey, any questions, sir?
If I have a witness to the case, which is a family member, do I got to enter that in with the county clerk?
Yes, you do need to file a witness and exhibit list prior to the hearing.
Okay, because
we're kind of close to that time frame. Usually I do 21 days, but we're pretty darn close to that already. So I would just indicate to file that at least 14 days prior.
Okay.
All right. Thank you both for appearing. You're all set.
Thank you. What a fucking douche. He's getting my Aunt Mary to go to court against me.
All right. We'll call the matter of Naomi Keaton versus Brian Fraser, file number 20-18252 DC. Do we have the parties on that matter present? All right, if you're present on the Keaton versus
Can you hear me
Fraser
now?
matter, you need to unmute. Yes, sir, I can hear you.
I'm Brian Fraser.
Thank you. All right, we're here today on a motion filed by Ms. Keaton, I believe,
Yes, sir.
looking to make some changes. All right, looks like she just appeared in our waiting room, so we'll send her in. Ms. Keaton, if you can hear me, I have called your case, so please start your video and unmute.
Am I on?
Yes, I can hear you. Thank you. So, Ms. Keaton, we're here today on your motion regarding parenting time. What are you looking to do?
I was just hoping to start some type of parenting time. I
Was your,
was just
so
hoping
your parenting time was suspended back? Is that right? All right. So you're looking to initiate parenting time after it was suspended, correct?
Yes, sir.
All right. And sir, are you in agreement or disagreement?
Disagreement.
Okay. What we would do then is hold a evidentiary hearing. Ms. Keaton, at a hearing, do you intend to call any witnesses or provide your own testimony?
Provide my own testimony, I think.
All right. And sir, would you anticipate calling witnesses or just providing your own testimony?
Do I have to be 100% decided right now?
No, I just kind of when I'm setting the time frame.
I'm
So if it's just
looking-
going to be the parties that
Yeah, it all really depends on the other party, but ultimately, my own testimony should be do just fine.
Okay. All right. I asked because, usually if it's just the parties that are testifying, usually we only need an hour. If there's more going on, then we set it for a longer time. My next 1 hour block is May 27th at 11 a.m. Do either of you have any conflicts with that date?
I do not.
What was the date? Sorry.
May 27th at 11.
No, that's fine.
All right, so I'm going to set you for an evidentiary hearing. Those are done in person. It'll be May 27th at 11. Given the child's age, there will not be a child interview.
Thank you.
If you do wish to have a witness appear, you do need to file a witness list. And if you want to submit any exhibits, you have to file an exhibit list. Those need to be filed 21 days prior to the court date. You can get a form for those from the front of the court. So we'll see you back here in person on May 27th at 11 o'clock. Any questions, Ms. Keaton?
Wait, okay. May 27th. So we're gonna have to come back to court before we do anything? Like, I'm not gonna get to see him like for his birthday or anything?
Correct, ma'am. So the court has to have a full, if there's no agreement, I have to have an evidentiary hearing where everyone presents their arguments. I have to fully review the best interest factors and make a decision. That certainly cannot be done at a 5 to 10 minute hearing. So this is a status conference to figure out where the parties are at and if we need that evidentiary hearing, which it appears that we do.
Okay, so if I do plan on having people speak, like witnesses or whatever, is there like paperwork that I have to file ahead of time, or like how does that work, I guess?
Yes, as I indicated, if anyone wants to have a witness appear, they have to file a witness list at least 21 days prior.
Okay.
What I don't want to have to happen is everyone thought we could get this done in an hour. And so suddenly if you each have numerous witnesses and we need more time, you're going to end up with a further adjournment out in time. So that can be a potential factor. If you guys are saying now that you think you need a bigger block of time, then we can address that right now.
I don't really see a need for a bigger block of time, but you know, yeah, I don't.
All right, so we'll stick with the hour and go from there. I mean, obviously, there's been no parenting time, it sounds like, for a couple of years, so we'll get the update of where everyone's at and whether or not resumption of that parenting time is appropriate. So I'll see you guys here May 27th at 11 o'clock. Thank you.
Okay.
Your Honor.
Yes.
Is there any way to like, can I at least like get phone calls until then, or?
I mean, I have to go through certain evidentiary rules. If there's no agreements between the parties, I have to have that full hearing. Your parenting time was suspended. So in order to reverse that, absent an agreement, I have to go through a full evidentiary hearing and address all of the best interest factors.
Okay. All right. Thank you,
All
Your
right,
Honor.
thank you. You're welcome. You are free to sign off, man. What we call the matter of Mackenzie Miller versus Kenneth Wood. File number 24-19833DS. We have the parties on that case present.
Yes, I am.
Okay, Mr. Wood is present. Ms. Miller.
Yes, Your Honor, I'm here.
Thank you. All right, we're here today for a few matters. We've got some motions as well as a show cause. Mr. Wood, the motions are your motions, is that correct?
Yes.
And what are you looking to do, sir?
Lower my child support and get parenting time for my kids.
All right, you currently have parenting time or not?
No, she's keeping them from me.
All right, is there a specific parenting time agreement or is it just simply as the parties agree?
We can't agree on nothing. That's why I filed the motion to get parenting time.
Right. I'm just asking about the order. So I do see an order back from December of 24, granting the parties, well, granting Ms. Miller's sole physical, granting the parties joint legal, and parenting time as the parties agree. So are you indicating that you've never had a specific parenting time schedule?
No, nothing. She was letting me see him, and then every time she gets mad, she stops me from seeing my kids, and it's just been back and forth. And I just want the courts to award me my time as a father. Huh?
The parent does have a right to seek a specific schedule. Your schedule is not specific, so we would have a hearing on that matter unless the parties can reach some type of agreement as to what that schedule should look like. What kind of schedule are you requesting, sir?
Right now, just maybe weekends to start it off, but I'm gonna go for 50-50, just like I have of my 13-year-old.
All right, Ms. Miller, what is your position on parenting time?
I believe that Mr. Wood should have supervised visitation with the children because he is a convicted sex offender. And there have been incidents in the past that I have reported to CPS.
All right. So obviously the parties don't have an agreement and you're really not close. So I don't think mediation would get you anywhere. So what we would do is set the matter for a court hearing.
Can I say something, Your Honor?
Well, I'm going to ask you, how much time do you think you need for a court hearing? Are you going to provide your own testimony only, or do you intend to call some witnesses?
On for parenting time?
So we're gonna have an evidentiary hearing, which is where you both get the opportunity to provide testimony, exhibits, or witnesses in support of your requests for you either to have parenting time, for her to say it should be supervised or otherwise. So if we have that, when we have that hearing, are you gonna call witnesses or just provide your own testimony?
Yeah, I'll call witnesses. I can call like the CPS and the cops that's been here.
Okay. So what I would do is give you guys a bigger block of time. So I would give you a 3-hour block of time. We have a date available May 4th. That's pretty quick. So if you intend to call witnesses and subpoena people, that might be too quick for you. I don't want to set it for a time that you're not able to get yourself prepared for. And that's, only less than a month away. So Mr. Wood, do you think you need more time to get ready than that?
A month away. No, I think I can get the people I need. I've already been in contact with them anyways before all this, so.
All right, I just want to make sure, I don't want to give you a time that then it doesn't work, or we have to have the hearing, you don't have your witnesses. So I could do May 13th, which is just
Okay, that's
a week
fine.
or so. All right. Ma'am, do you have any issue with May 13th, any conflict?
No, Your Honor.
All right, so I'm going to set your case for a evidentiary hearing on May 13th at 1 o'clock. Evidentiary hearings are in person, so you'll be here. The children are young, so there would not be a child interview. And if you do wish to call witnesses and have exhibits introduced, you do need to file a witness and exhibit list 21 days prior to the court hearing.
Witness
also
and witness and what?
Exhibit list.
Exhibit list. All right.
Then we also had a show cause. So in front of the court, what's the issue on the show cause?
So the show cause was adjourned from May 4th to monitor Mr. Wood's payments. His monthly obligation is $703. Last month, he did pay $710. I would like to adjourn a couple months, maybe just to keep an eye on that and make sure that he continues to make his monthly obligation.
All right, I think what we can do is readdress it again on that May 13th date, just to make sure payments are coming in. Then we'll also see what happens at that hearing. Ms. Miller, any questions?
No, Your Honor.
Your Honor, I also have the thing on my child support today too.
Did they call for you already?
Yeah, they put us on hold because it was.
All right, so if your case is not called, you need to be muted. Thank you. So Mr. Wood, you also have a motion regarding support. What are you asking for there?
The lower, because I haven't worked since last year and I just started picking up work just now, like the last 3 weeks. I'm losing I pay rent and I pay other child support and I pay a lot of bills. $700 is just a lot and I can't afford that right now.
Okay.
And I don't mind paying.
I'm going to address that at your evidentiary hearing because again, that'll give us more time to address it, as well as, if there are any changes that might impact and require a new support review anyways. So we'll adjourn your support motion to that same date when we hear all the testimony, okay?
Okay, so there's nothing happening on the support then? I have to come up with the $700 again?
Correct. If we make changes, your changes would be retroactive back to the date you filed. So if you will get some credit for that if there are changes, okay?
Okay.
All right. Thank you both for appearing. I'll see you back here May 13th.
Thank you, Your Honor.
Next call, the matter of Chad Mertz versus Sabrina Mertz, file number 18-17404DM. Do we have the parties on that matter present?
Yes, Your Honor.
Okay. Is Sabrina present? All right, does not appear that she is present. Sir, what's the current status regarding custody and parenting time?
Currently I have sole physical and we have joint legal. And it's supposed to be during the school year. It's like the standard parenting time. She gets them. She's supposed to get them every other week, but when she's moved back, because she moved back a little over a year ago, the kids have been going over there a lot more. Since she moved down by Detroit, so it's a lot easier with her back here in town for the kids to go over there.
Have the two of you discussed making any changes to the order?
We've tried to discuss it, but sometimes we just don't get along, so it's kind of hard.
Have you discussed this court date with her at all? I guess I'm curious. She's not here.
No, I have not discussed this with her at all.
Okay. These are her motions.
Yesterday,
correct?
Sorry, I interrupted. I seen her and my daughter yesterday because ever since she's been with her mom, my daughter's on truancy. So we had a court date yesterday to go down there and talk to the counselor, and my daughter had to go through all that.
Well, these are her motions. So typically when someone files a motion and they don't show up, the motion gets dismissed. What's your position on that?
Yeah, dismiss it, and I can try, because I was actually about to file a parenting time violation because she's been, my daughter will go to her house, but it's because she'll just pick her up from school. And then she goes over there. She's supposed to have them every other weekend, but it's been a lot, and I haven't tried to push it because I don't want to. My daughter hasn't seen her mom in like 5 years, so I haven't spent a lot of time with her in 5 years.
All right, thank you. Well, it is now 10:30. This matter was set for 10:15. Mom is not showing up, and they are her motions. So given her failure to appear, the motions will be dismissed. Any questions, sir?
No, Your Honor.
All right, thank you for appearing. You're all set.
Thank you.
Court calls matter of Tara Johnson versus Kenneth Johnson, file number 18-17275 DM. Both parties are present. Front of the court, what is the status of this matter?
The friend of the court received information from the parties that they are married. So there is an attached uniform child support order that would create a potential overpayment. At the last hearing on February 11th, both parties failed to appear, but the court did order friend of the court to place a hold on the case to address anything currently charging and arrears and any potential overpayment. And then the case could potentially be administratively closed.
Thank you. So Ms. Johnson, is that correct that the two of you are remarried now?
Yes, that is correct.
Okay. And so because of that, are you willing to waive any back support that might be out there and waive any current support?
Yes, I am willing to waive any support.
All right, and you're essentially making that decision because the two of you obviously have remarried, correct?
Yes.
All right, and the decision to waive any support, that is your own decision and you're making that freely and voluntarily, is that correct?
Yes.
Thank you, Mr. Johnson.
Yes, sir.
You agree that the two of you have since remarried?
Yes.
And you also would do a waiver of any support that is previously owed or any payments, any current payments, correct?
Correct.
Okay. Well, so based on the statements from the parties, I do think it would be appropriate to discontinue the support as they are remarried. We both have agreed to waive any current payments as well as any overpayments. And the matter could be closed and finalized. Friend of the court, do you think there's anything else we need to address on the record?
As long as the court is a friend of the court, the ability to adjust the balances and then the money that is on hold, anything on hold could go to the state or county and then be released to the defendant once that's done.
Yes, I would order that given the situation in this matter. All right, Thank you both for appearing. You are all set with us.
Thank you, sir.
Thank you.
For our next call, the matter of Gavin Van Lushen versus Savannah Hipio, file number 19-17779 DM. Do we have the parties on that matter present? All right, if you're present, just let me know you're here and you can hear me okay.
Yes, sir. I'm here.
I'm here.
Thank you. This looks like this case was a referral to the friend of the court following a ex parte motion filed by Ms. Hipio. So Ms. Hipio, what are you looking for the court to change?
I would like to change our legal custody. I'm looking to get full custody of our daughter because of the past incidences that have happened with Gavin. I no longer feel that our daughter is fully safe in his care full time.
Okay. And Mr. Van Lushen, are you in agreement or disagreement?
Disagreement.
Okay. Then what we would do is set the matter for a evidentiary hearing. Ms. Hipio, do you intend to call witnesses or just provide your own testimony?
I can get some witnesses, but as of right now, just my own testimony.
All right. And Mr. Van Lushen?
I can as well get.
Well, I know everyone can get witnesses. I'm asking, do you intend to call witnesses?
At this time, no, sir.
Okay. Well, what I think I could do is, I think it's just going to be the parties testifying. I think that hour and a half would certainly be sufficient. Do either of you have a conflict with May 27th at 2:30?
I do not.
Oh, that works fine for me.
All right, so we're going to set the evidentiary hearing for May 27th at 2:30. Evidentiary hearings are done in person. The child is 9 going on 10, is that correct?
Correct.
Correct.
So given the child's age, a preference interview would be done. So whoever has the child that day should have the child here at 2:15, so I can do the child preference interview. And if somebody can be here to take her home or sit with her in the hallway after, that would be appropriate.
Absolutely.
Okay.
If you intend to call any witnesses or file any exhibits, you do have to file what's called a witness and exhibit list 21 days prior. Any questions, Ms. Hipio?
No, sir.
Any questions, Mr. Van Lushen?
No, sir.
All right, thank you both for appearing. You're all set. We'll see you back here May 27th.
Thank you so much.
Next on the docket is the matter of Tracy Hoffman versus Jared Hoffman, file number 22-19163 DM. Do we have anyone present on that?
I'm here, Your Honor.
Thank you. From the court, what is the status of this matter?
This hearing was adjourned from February 11th to monitor the defendant's income withholding. The defendant was to make payments until the income withholding is collecting as ordered. The obligation is $424 with a balance of $3,897.76. Since the last hearing, the defendant did submit medical information regarding his inability to work with an anticipated return to work without restrictions as of March 30th.
Thank you, sir. What would you like to say?
She is correct. I was basically bedridden the whole month of March. I had a bacteria infection. Since the 30th, I've been hitting the treadmill trying to get my strength back. I have an interview Friday with Petoskey Plastics. I got that interview through PMP staffing for Petoskey. I can return to the farm. I just found it was an unsafe work environment, and I had spoke to front of the court about that as well. But if this interview doesn't pan out, if I will return to the farm if I have to, till I can find something better.
All right, I'm going to adjourn you to June 3rd so we can get the update on employment. Obviously, if you get employment, make sure you let your caseworker know.
Yes,
and
of
also
course.
make sure you're making any payments until a withholding order is set up. Okay.
Well, as soon as I get that new employment, I'll get the tax exempt ID and pass that along in front of the court.
All right. Any questions, sir?
No, thank you.
Okay. You're all set. Mont Ross versus Adam Fletcher. File number 24-19681 UN. Do we have the parties on that matter present?
Mr. Fletcher is here, Your Honor.
Your Honor.
Thank you. For the court, what is the status of this matter?
This hearing is adjourned from February 11th to monitor the defendant's employment status and good faith payment efforts for February and March. Since the hearing, there has been no payments. The defendant's obligation is $360 with the current arrears balance of $39,180.56.
All right, thank you. Mr. Brown, are you going to speak for your client, or is he going to address his employment status?
Your Honor, he can address his employment status. I did speak with him about it yesterday.
Thank you. Mr. Fletcher, what would you like to say?
I would just like to say that I did start DoorDashing. I have a $50 payment I'd like to make to the court today. And then in the meantime, my taxes from back when COVID hit have been messed up. ID, like I had to go to the IRS office to verify my identification. And I do plan on this month, and then hopefully that'll take a chunk off. I haven't received taxes back or the stimuluses since 20.
All right, Mr. Fletcher, your connection's pretty bad. I was getting most of it for a while, but now I'm not getting much of it. It looks like you might be frozen. So if you can hear me, maybe you could try turning your video off. Sometimes that improves the audio.
Okay, I'm still here. Okay.
All right. So speak slow because we are having trouble hearing you. So just give it time, relax. You were talking about your taxes and perhaps a payment coming and some money available soon. So explain that to me.
Well, I'd like to make a $50 payment today. And then the taxes, I'm just, once I verify my identification at the IRS office, I'm sure they'll release my taxes and there would be a good sum there to pay some of my tax, child support.
All right. So with the understanding that you're going to make a payment today, as well as look at some additional payments and work on the tax issue, I'm going to adjourn you to June 3rd to give you some time to get those things done.
I do appreciate you, Your Honor.
Thank you. Mr. Brown, any questions?
No, Your Honor. Thank you.
All right. Thank you. All right. You may both sign off. Thank you.
Thank you. Thank you, Mr. Brown.
Not appear that either party is present. In front of the court, what is the status of this file?
I'm here. I'm sorry.
Oh, sorry. Thank you.
This matter was adjourned from January 14th to monitor the defendant's payments. This is an arrears only case with a current balance of $3,232, with the last payment received in March of 2026 in the amount of $217. Back in September of 2025, the defendant did sign a stipulated agreement with us where he had agreed to pay $100 a week or get in contact with us if there's going to be any issues making a payment. Mr. Leland has always been very good about contacting me if there's going to be any issues regarding those payments.
Thank you. Sir, what would you like to say?
Just say we're just now starting to pick up with work. Like I'm out working right now. I was hoping I didn't miss this opportunity the first time when I was in, but yeah, I'm going to make a payment today. Like I told her the other day when I talked to her, but I'm going to make one today too. I got to get to the bank. I don't get out of work in time on Monday sometimes or Tuesday to get to the bank to cash my check and put money in there to send. So I just do my best as much as I can.
All right, I'm going to adjourn your case to June 3rd, given your payments. If you are making consistent payments, of at least $100 a week, you can speak to your caseworker before that court date, and she may just move it out a couple more months to keep watching your payments. So, showing up isn't easy for you. If you're making those payments as required, then you might not have to be here next time. We certainly expect at least some effort in payments. But like I said, if you make those at least 100 a week, we could we could adjourn that hearing out without having you appear. But if you don't meet that benchmark, we'll see you here June 3rd, okay?
Okay, thanks, sir.
All right, thank you. You're all set.